Welcome to episode 141 of the Inside Job Boards and Recruitment Marketplaces podcast. I'm one of your two co-hosts. I'm Stephen Rothberg, the founder of College Recruiter job search site. And as a fully recovered lawyer, or as my wife would like to say, a recovering lawyer, today's episode is of great interest to me. We're going to be talking about UK, EU, and inevitably some US laws that are starting to and definitely will be impacting job boards globally. But before we get into the meat of that conversation, and it'll be an extended episode, we're going to go longer because we have two guests and a really detailed, in-depth kind of conversation coming up. I should probably hand over the baton to my co-host, Peter. Peter, good to see you.
Thank you. I'm Peter Zollman of the AIM Group. We do consulting, content, and conferences for job boards and recruitment marketplaces all around the world. Do this podcast too. Today we're joined by two esteemed gentlemen. You'll notice I've left out Stephen.
Wise
Hey,
choice. The more I'm left out of this conversation, the better.
no, just leaving you out of the esteemed gentleman label.
Okay.
We have David Viney, who is sitting in the south of France right now, in near Montreux. He is based in London ordinarily, except in August when all of Europe shuts down. He is the CEO of Alchemy Consulting, and he is paying a lot of attention to what is happening with AI and job boards and recruitment marketplaces and all of that good stuff. And it's good that somebody's paying a lot of attention. We are too, but it changes so fast that the rules are still undefined and changing by the moment. And sitting in Ohio near Cleveland is John Hyman. He is with Wickens, Herzer, Panza, a law firm, but I'm not going to talk about his lawyering. I'm going to talk about number one. He is the number one person I follow about recruitment on LinkedIn. If you do not follow John Hyman, write down JONHYMAN and follow him. He's terrific. Number two, he writes a Substack about civil rights in the U.S. and about the current state of affairs here. And number three, he publishes from time to time worst employer anecdotes about some serious idiocy by employers. And it is always a fun read, except for the employer and the employees involved.
And I'm
So
so happy that I have never made that list.
you you're yeah, you keep trying though, and that's the sad part. In any case, let's talk a little bit about AI, job boards, recruitment marketplaces. And David, let's start with you. State of the regulation in the UK and Europe as it stands now and as you expect it to evolve. And the timer says we're at 3:45. We've run long already. Try to boil that down to about a minute and a half, if that's possible.
Will do. So, I mean, I guess first up, an obvious question is: are we expecting to have our own equivalent of the EU AI Act in the UK? And the simple answer to that is there is a private members bill which has been mooted. It doesn't have government support, so that will almost certainly not happen. The more general kind of approach to AI is sector by sector. So you have 19 different regulatory authorities that are baking AI into each of their own guidelines, their own recommendations. So the most notable one amongst all of that is the financial services sector, where you have an emerged requirement now for a named responsible and accountable board member for AI within financial services organizations. So that will continue to play out, that sector by sector approach. But for job boards, I mean, the really key area is the UK GDPR legislation, which, just to confuse everyone, post Brexit is not the same thing as the EU GDPR. We sort of got our own little mini version now, which has been sort of updated for AI specifically. And it's interesting because, if you think about it, it's quite an interesting angle to come at the problem, right? How is data being used? Is it being used to harm individuals? And individuals can include, of course, candidates for jobs. So it's an interesting approach that the responsible regulator for the UK GDPR is the Information Commissioner's Office in the UK. and they did a big kind of voluntary exercise at the end of last year, where they had sort of just over 30 different larger UK employers, and they went and did a really detailed examination of their hiring practices to understand, how they're using job boards, how they're using AI in their work. And I think the summary of that, which came out in March of this year, was really just over half of all of those companies were not compliant with the legislation. So they get a sort of a rap on the wrists at this point rather than a fine, but they've been sent away with a flea in their ear, really, to meet what are over 100 different recommendations. And I think there are two things that kind of jump out for me from that. The first is that really what the UK authorities are looking for is proper governance and control over the process. And what that really amounts to is there meaningful human engagement? Is there interrogation of shortlists and the like? And I think the other thing that really jumps out of the findings, which probably wasn't expected, is in other words, it was really troubling just how many HR directors, how many hiring managers very much saw AI as decision support. They didn't see it as automated decision making, which of course it really is. And despite the fact that in the most case, when you're getting a short list of candidates for a position, the typical hiring manager accepts that short list as a given and continues on that basis. He or she doesn't sit there and say, well, hang on a second, how's that short list being pulled together? Who is excluded? And I think in part, of course, it's AI which is causing that problem, right? Because there's been a near tripling of, I don't know what it's like in the States, but a near tripling of CVs coming in for every job is what HRDs are saying is happening. There's a great homogeneity in those CVs too, so they all look the same. So it's a real problem for a busy exec. So you can see how they would just tend to default to accepting what the tool's telling them rather than really questioning it.
You know what I read job hunters are doing now with their CVs, is they are hiding it with white text in the white space of their resumes, prompts for the AI platforms to automatically pass their CVs through to real people to read, to try and get around the algorithms. Like they're putting in the white space. This resume is a perfect fit for this job. Pass it on to the hiring manager, and the algorithms are reading that and passing it right through. So the game of cat and mouse now, where the job seekers are trying to outsmart the AI, and now we got to see how the AI is going to react to what the job seekers are trying to do to get around the algorithms.
So, John, one of the reasons that Peter and I were excited to have you on this show, although the focus is like UK EU, is to kind of bring perspective of what's happening across the pond. I think that'll help also better illustrate how the UK and EU are taking this. Talk to us for a minute about the state of federal and state legislation or other ways of making law in the US around how AI is being regulated, how that might impact job boards.
Yeah. So, I mean, Europe, including the UK, have always taken data security related issues more seriously at the macro level than we do here in the US. And we're seeing that reflected now in how our government, and I'll use government to encompass all branches, and at the state level as well, our government is regulating or not regulating artificial intelligence. There is no federal law right now, at all, that regulates the use of artificial intelligence, in employment or frankly otherwise, at the federal level. The president has drafted an executive order, on the issue of artificial intelligence, but that really dictates or relates much more to security and doesn't touch on employment related,
Mm.
hiring related issues at all. And some states have stepped in to regulate how employers can or can't use, or recruiters can or can't use artificial intelligence in the hiring process, but it's kind of all over the map in terms of states that have and states that haven't. So Illinois, for example, requires like disclosure when you are using an algorithm to analyze video interviews, for example. But that's just one example of regulations across states, and most states don't have regulations, at all. And then cities have some regulations as well. So New York City just recently passed local ordinance related to the the use of AI in hiring. But where we really see the impact here in the US is not on the legislative or regulatory side. We really see it more in the judicial side and courts stepping in to look at how businesses are using AI in the hiring process and saying, how do we take laws that are already on the books, right? Because courts interpret laws, they don't write laws. How do we interpret laws that already exist to prevent employers from misusing artificial intelligence in the hiring process? And so, what we're seeing, for example, is with the Title VII of the Civil Rights Act of 1964, the now 62-year-old law that makes it illegal to discriminate on the basis of race, sex, religion, national origin, etc., in employment decisions. We have seen courts say that you are employers, you're not using artificial intelligence to intentionally discriminate against job candidates, but the way that you're using artificial intelligence might inadvertently tend to screen out particular protected classes of individuals based on race, based on sex, based on disability, based on age, what have you. And courts are using what is referred to as a disparate impact theory of liability. You have a facially neutral rule, a policy, a procedure, a practice that on its face doesn't intentionally discriminate, but how it's deployed tends to discriminate. And courts are using that theory of liability and saying recruiters, hiring managers, employers, staffing companies, whatever, you are using AI in a way that tends to screen out Black applicants or female applicants or disabled applicants, and therefore we're going to require you to justify the job relatedness and business necessity for using AI here in order for your practice to pass muster. And the problem is that most businesses that are now using these AI related tools haven't done the vetting required on the front end to make sure that their use of it on the back end doesn't discriminate. And that's where we're seeing the push and pull right now.
Yeah, I mean, can I just build on that real quick? I mean, I think one of the areas that I think that the US has been a leader in is actually doing the research, doing the hard work to understand what the harms might be. And there's a really interesting report from Stanford's AI unit in May, where they were looking at a screening tool called Pymetrics. And what they found is out of 4 million job applications, there were 40,000 Black or Asian candidates that didn't proceed to interview that previously in the baseline data would have done. So you're starting to see that, that emerging clear evidence now in kind of peer-reviewed, large sample size research that shows that there really is adverse impact. And I think that the really sort of interesting aspect of that is Pymetrics are one of the good guys, right?
Okay.
They have a stated objective of trying to eliminate bias in hiring, and Stanford were expecting them to be an exemplar. So you can imagine if that's what they found looking at one of the good guys, you can only imagine what some of the bad guys are doing in terms of
And,
their
and
tools.
and employers, in their part, are rushing to try and find solutions to simplify their processes, and so they're going to these platforms, and they're engaging without doing any. They're trusting the AI vendor without doing any vetting whatsoever. For has there been, what is the impact analysis here? Does this have an adverse impact? What does this do to our pipeline and funnel and our ultimate final applicant pool? The employers are trusting the AI to do all that for them without doing any vetting on their own of what that actually looks like in practice, as either applied in general through the platform or applied to their particular pipeline of applicants. And that's where employers, at least here in the US, are getting themselves in trouble.
I want to direct this first to David, but then I want John to weigh in too. Seems to me that with multinational, semi global, international job boards, recruitment marketplaces, by definition, they have to adhere to the most rigid, the most challenging standard. So, indeed, and we'll talk about them shortly because they've just pulled an interesting step by placing all the liability on the employer. But let's put that aside for the moment. David, in Europe, Stepstone and Indeed are the number ones mostly. There are some markets where they're not. Do they have to follow the most stringent rules, and are they doing so? And likewise, Total Jobs Stepstone in the UK, Indeed in the UK. And then, John, same question to you for the US. But David.
Sure. Yeah. I mean, I think the first thing to start with is obviously the EU AI Act is extraterritorial in its jurisdiction, so similar to the GDPR regs that came before. So really, anyone who's serving the EU market, hiring into the EU market, is going to need to comply with the legislation. I think another thing which you know seems to have escaped a lot of people's notice is that there are already provisions of the EU AI Act in place that affect the hiring process, the so-called prohibited practices, which have been illegal now for some time, and mostly those fall into the category of using biometric data. So whether to infer emotions, for example, whether a candidate is engaged with the conversation and excited about the company, whether a candidate's lying, using AI to score and infer that kind of behavior is a total no-no. There's also the sort of narrow use case of actually using AI to categorize people, whether that's by racial characteristics, gender, or sexual preference, or any of the above. But I think the former in particular has already had quite a large impact because there was a real growing trend towards employers using video interview tooling, and you mentioned Illinois, John. I think there's a real kind of synergy there with the prohibited practices in the EU. So the stuff that already applies, but beyond that, I mean, for most practice, having AI in your job board is not illegal. Number one, right? Again, like with the UK legislation, though, it's all about how you govern it, how you control it, how much meaningful human intervention there is in the loop. I think where the EU differs from the UK, and this is really important for the conversation to come around Indeed and similar, is the UK GDPR is all about the employer. It doesn't really talk to the responsibilities of the vendor in any meaningful way. Whereas the EU legislation does put very clear responsibilities on both the employer and the provider of the platform. And I think it's the other part of your question, I think, really was, so are people already there? Are they already complying? And I think the answer to that is a very sound no. And there's a very good reason for that, which is that the legislation, in a way, was ahead of the detailed guidance. So there was an intent to have the standards bodies in each individual country formulate detailed guidelines for employers to follow in order to be in compliance with that kind of governance and control aspects. But that has lagged to the legislation significantly. The latest date for it to be published is Q4 of this year. The deadlines for compliance for this kind of, if you like, the broad field of hiring has been extended to the 2nd of December of next year. So let's call it, let's say December they come up with the guidance. It's really only going to leave 12 months of runway for the vendors and for employers to get ready to some instructions they can actually use. So there's always a possibility, of course, that the deadline might be shifted again. Had it not been shifted, we'd have been talking about it right now. It would have gone live on the 2nd of August.
Yeah, and we're recording on August the 6th, so it would have been 4 days ago that that world would have changed.
Yeah, I mean, for an employer here in the US who has operations touching on multiple states or touching internationally, it is operationally unsustainable to maintain 50 different sets of guidelines and then adding in like a UK element or an EU element on top of that. To me, what makes the most sense, and it's really no different if I'm drafting an employee handbook for a business or giving them guidance on what they should be doing with their AI hiring practices, the answer is going to be the same. You find the most stringent standard that's out there and you make that your default because you are safeguarding your practices against future changes down the road. You look at what the most stringent is now, and you say that if the EU is the most stringent, but I'm in Ohio. Ohio doesn't have any AI laws, but someday they might. The laws in Ohio change. I'm already going to be compliant most likely because I'm now adhering to the most stringent law that's out there. And in this day and age when hiring is global, can you really say that I'm an Ohio employer, so I'm only hiring from a pool of potential applicants in Ohio when you don't know where resumes are coming from. Resumes, you put a job out there on Indeed or LinkedIn, even though you're here in Ohio, those applications are going to come from all over the place, right? And so you really have to default to whatever the most stringent law is out there. You don't want to have 50 different laws or 50 different standards because now every time a state or a country does something different or makes a change, you know, have to change. You become a compliance monitor for global AI rules and regulations, and now that becomes your full time job. And so I really think the smartest thing to do is just find what the most what the strictest set of guidelines are out there, and then deploy that universally as your set of rules for how you are going to uh, uh, internally regulate, the use of AI for your recruiting and hiring within your organization.
And what John is suggesting there reminds me 187 years ago when I was in law school and working in the corporate legal department at Honeywell. I was literally revising the employee handbook. We were a very big, very decentralized company. And I had to go through every single policy the first probably month or two that I was there. And what is my boss called a blue sky? What is the most stringent policy when it comes to time off, to payroll timing, to vacation or leave, jury duty, all of that kind of stuff. And boy, did I find some incredibly inconsistent laws. Some states had like no law about jury duty at all. Are you allowed to take it? Are you allowed to, do you have to get paid? And other states, it's like everything was buttoned down. It was really interesting how disparate it was. David, I bet over the last year, I have had probably 50 conversations with job boards or related talent technology vendors about these sorts of issues. Overwhelmingly, the response that I get back is, well, our technology does a really good job in helping to surface candidates that otherwise the employer would not have seen. Therefore, we're a good guy. Therefore, we have nothing to worry about. Your response.
Yes, I think I might go back to the Pymetrics example actually and expand on that a bit
Mm.
because it's actually very instructive. So as I said, Pymetrics are very very mission and purpose driven about eliminating bias in hiring, and their own internal tests weren't showing any signs of any bias because they were looking at it in the aggregate. But of course, as you know, in the US, the sort of guidelines are very clear. You have to look at it individual job by individual job, and that's the work that Stanford did really. So you might have a scenario where, say, a black candidate was perhaps 20% more likely to get a security card job, but 20% less likely to get a CEO job. And the net result was it looks fine in the aggregate, but actually it's absolutely not okay on an individual case by case basis. So I think, I mean, what I would say is a key part of the kind of vendor response to this, I think, is around explainability. The truth is that there are a lot of capabilities within AI that are what are called in the trade emergent. We don't quite understand how the AI has come up with that. How has it generated that particular shortlist? And I think it's going to become important for vendors to be able to explain their algorithm and to test it properly on individual cases rather than just rely on aggregate data where it's all a wash. And also, I think more broadly, I think it's interesting the difference in regulatory approach around the world. I think a lot of that is due to the fact that the harms haven't been clear. The benefits have been clear, but the harms have not been clear. I think as the harms become more clear, I think there'll be more of a settled position in the long run over whether it needs to be harder regulation or lighter touch.
It's hard to know if you're one of 200 people who applied to a job and you didn't get it, especially if you weren't a finalist, why you didn't
Yeah,
get it.
exactly. And the other thing about sort of Pymetrics again is a good example. That tool's it's 90% of employers now globally use AI in hiring shortlists. So that's the World Economic Forum numbers came out this year. So it's there. It's everywhere for all intents and purposes. But really, one has to question: do we know what we're doing with it? Do we really know what we're doing with it?
That brings me to one of the things that I want to direct to John first, but then also to you, David. Auditability. AI seems to be pretty much a black box. There's no way to say to AI, okay, why did you include these 10 candidates? And why did you exclude these 50 candidates? Granted, you can ask it and it'll probably tell you, but there's no real audit trail. John, do you think that's a big problem? Is that not an issue? Is that the crux of the matter?
It's all of the above. Aside from it not being a big issue, it's all of the above. It's a massive issue. I mean, that's the issue there in a nutshell here, at least here in the US. Because without that audit trail, without that information, you can't vet whether the algorithm is disparately impacting black candidates or female candidates or disabled candidates. That's like the most high profile case we have right now in the US on the issue of AI and hiring is Mobley versus Workday, which is pending in federal court in California. And in that case, the plaintiff, Derek Mobley, says he applied for like over 100 jobs through Workday's AI platform through various employers. And or through Workday's hiring platform and through with various employers, and the AI that screened his resume dinged him for every single job, which he says was because of his age, he's over 40, because of his race, is black, because of his disability, he has anxiety and depression. So far, like the case is it's been pending for a couple of years, but it's very early in the case. And the issue that's been litigated so far is can the employer be jointly liable with the applicant tracking software, and the court has so far answered that question yes. And so, as an employer, you're responsible for the decisions that are made by your applicant tracking software vendor. And if you don't know how or why they're making the decisions they are making, you have left just a giant bullseye on your back for any denied applicant to who belongs to a protected class, which, by the way, is just about everybody, to sue you when they are denied employment. And so you have to know how these decisions are being made and why certain candidates are being passed through and certain candidates are being denied. And if your vendor cannot provide that information to you, it is time for you to get a different vendor. Because I can also guarantee you what these contracts say is AI vendor, whether it's Workday or anybody else, their contract says, and by the way, employer, these are your hiring decisions, not ours. And you are indemnifying us for any liability that we may incur as a result of your decision whether to hire someone or not hire someone based on the use of our software. And so the employer is taking all the responsibility, all the liability, and has no idea why candidate A gets passed through and candidate B gets screened out. And if candidate B is 55 years old, black and in a wheelchair, they sue you for age, disability, and race discrimination, you better know why that candidate was screened out and have an explanation as to why the algorithm chose the white, non-disabled candidate under the age of 40 and did not choose the black disabled candidate over the age of 40. Otherwise, you're going to have a big discrimination problem that you can't explain when you're holding the whole liability bag in your hands. So,
And and John, just to follow up, can you as like the chief human resource officer trust what your vendor is telling you? Because I'm hearing that too. I'm hearing HR people saying, well, XYZ vendor said to us that their use of AI has been proven to be non-discriminatory, and they check the box
yeah, I
and they
mean,
move
it's
on.
trust but verify, I suppose. Like it's one if the vendor's going to say, "Yeah, we've vetted our algorithm and it does not disparately impact on the base of any protected class." It's great they're saying that. All right, now show me the reports and prove it to me. And I want to be able to put eyeballs on that data and then give it to someone who can explain it to me, because maybe that's not the chief human resource officer at pick your company. Maybe they need to uh bring in a third party who can then explain to them, yeah, this is cool and this passes muster, or hey, hang on, here's all these red flags that you need to think about before you sign the contract and onboard this vendor, because I don't think their data says what they say it says.
And speaking of like handing it off to somebody who can actually verify that. So David, I would imagine that this is a bunch of work that you're working on. How often are you seeing vendor claims just being more aspirational than actual?
Well, I think I'd be lying if I said that the companies are falling over themselves to do this kind of work at the moment. And I think where a lot of organizations are is sort of ISO 42001 certification initially as a kind of an international standard for governing AI. But all that really does is put in place a sort of a set of coat hangers or framework to do your governance from. There's still then the meat of it, which is in this case, what would you ask for from a vendor? How would you, ascertain that it's enough? I think a couple of things I'd kind of point to that are interesting in this space, just to build on what John was saying. I think the first thing is I would want to see a new report from the vendor every time there's a material change to the underlying algorithm. Not just accept it at the beginning as part of a procurement and then not revisit it subsequently. So I'd want to see that it becomes more of a business as usual sort of an interaction between the vendor and the employer. And then I think just sort of focusing more narrowly on the EU picture, we talked about the EU AI Act, but there is an additional product liability directive which is expected to be adopted into the laws of most EU countries by the end of this year, and that puts a lot of additional, almost manufacturer liability level responsibility onto the vendors, the AI providers. So they become a little bit like a car company. You know what I mean? If they have a few car crashes, they're going to be in trouble. So I think that product liability directive in particular, laid on top of the EU Act, is going to drive this conversation in a much more meaningful way.
I want to just very briefly, we've got time for one or two more questions. I'm going to take one. I'll leave the last one to Stephen and he'll wrap up. Indeed, this week, last week, a couple of weeks ago, seemingly, and I'm not a lawyer, don't want to be a lawyer, don't pretend to be a lawyer, and did
But
not
he,
read.
but you do enjoy paying lawyers.
No, I don't enjoy paying
Oh,
lawyers
oh, okay,
either.
my mistake.
And it's always painful. But Indeed seems to have changed their terms and conditions basically to say to employers or any user, hey, all of the liability is on you. We accept no liability. It's all on you. Good luck. God bless. John, is that it is overstating, but is that a fair portrayal? And can they do that, or are they going to be in a workday situation where Joe's going to sue Indeed and say, "Hey, you haven't passed my resume through."
They're in a workday situation. So, yeah, I mean, we're years away from finding out what that really means here. I mean, Workday is arguing, as Indeed will argue if they're sued in a similar case, that look, we're not the employer. We didn't make the hiring decision. We're just passing on data to the employer, and they're the one ultimately making the decision. And the hiring entity, the employer, is pointing the finger back and saying, "Yeah, but we made that decision relying on the data that you provided us based on your algorithms," and they're going like this. And the plaintiffs' lawyers, frankly, are happy, they're thrilled to have them point at each other, because the answer is, to a jury at some point, someone made this decision, and so employer says AI vendor did, AI vendor says employer did. We don't care. Find one of them responsible. So, the employer, the plaintiff is happy to have them kind of point the finger at each other. But yeah, I think you're right. I think Indeed is going to have the same problem that Workday has, which is ultimately it's their algorithms. They might not be making the ultimate decision, but the decisions are being made based on their data, the data that they're providing.
Yeah, I think one of the things that Stanford talked about in their report was this. That I think they used the term algorithmic monoculture. So this idea that tools like Workday, Pymetrics, which we talked about earlier, they're used by multiple employers. So if you're somebody who is falling foul of the algorithm with one employer, you could be falling foul of the algorithm across multiple different applications for the same reason. And the way I'd put it to people is, imagine that's your son or your daughter, and they're applying for a job and they just cannot get a look in. It's something we need to take seriously. And I think, from my point of view, I mean, it's not just hiring; it's just more generally across AI. I think the number one skill in the modern day and age is the ability to interrogate AI, to understand how it's forming its conclusions, where some of the limitations might be, where some of the outright hallucination might lie. I mean, one thing it's interesting. I was talking to a group of HRDs recently, and they seem to be completely unaware that when someone sends them a CV that they've used an LLM to customize towards a job description, that there's somewhere in the region of a 10 to 20% chance that there'll be a significant hallucinated element in that CV. And if someone's firing off like 50 applications in a day, just people do sometimes, there's a chance that it would have escaped them, that escaped their notice, that they've ended up essentially fabricating their CV with an employer, and they then have to go into an interview, of course, and justify the fabrication. So, I mean, there's stuff to take seriously here, and I think the skill, as I said, in the modern day and age, is can you interrogate and understand and explain what your AI is doing? It doesn't get you off the hook. You're still, the decision maker ultimately. You're using a tool, but you have to form a view.
Yeah, and I think the problem is right now, too many businesses are just relying on hope. We hope the AI is giving us correct information. We hope the AI is not discriminating. We hope, and hope is a terrible compliance strategy. I mean, hope will get you talking to me, and getting very expensive legal bills in the mail to fix your problems, and it's great for me, but not great for businesses. So I would, if there's kind of one takeaway from all of this today, it would be, don't just you gotta vet, and you gotta make sure that your vendors are taking this stuff seriously, and that when they're telling you that we don't just our algorithms don't discriminate, that you just don't take them on their face, and that you actually double check their work, because otherwise you're begging for a lawsuit.
Yeah, and I think for folks who are going to use people like John or David, I think John and David, you'd both agree you'd much rather have those people come to you to help them stay out of trouble than to help them figure out how to get out of trouble they're already in. Ounce of prevention is worth a pound of cure.
Well, what's better for the business, versus my bottom line, because they're very different. So my bottom line, it's much better you come to me after this blows up in a huge mess. But for a business, that's the worst possible time to talk to a lawyer.
Yeah,
You wanna talk to your lawyer on the front end, so it can all be done correctly on the way in, as opposed to me trying to fix it on the back end, which would cost 10 times, 50 times, 100 times more in legal fees.
yeah, and the brand of the employer and all the rest of it. So, just to wrap up, then, John, I'll go to you first, and then David. So, I'm a job board owner. I'm not actually speaking about myself, just the audience. By the time this episode airs, late August, they're going to have a little over 4 months to go before the end of 2026. What should they be doing in those 4 months to help ensure that they are on the right side of these laws and regulations, whether they're coming out of the legislature, whether they're coming out of the courts? John, go first, and then we'll close with David.
In my world, I would say to make sure that you have your impact analyses buttoned up, so that you can do more than just check the box that says "and we don't discriminate," but that when a client comes to you, as more will do, and say, we want to see the data and then verify it for ourselves. You can provide them the data that you relied on in a real and legitimate and meaningful way, so that your customers, your clients can have confidence that they are not going to be making discriminatory decisions based on the use of your platform and your algorithm.
And David.
Yeah, very well said. I mean, the only thing I'd add to that possibly is, I think if you really want to go the extra mile and delight and get ahead of the problem, a really interesting area is to start to put more functionality into the platforms to help people understand, the recommendations that the AI is giving you, what some of the sort of shortcomings might be or risks might be, and the ability to tweak settings. So that you could see a different version of the shortlist if you press the different button. I think it's certainly something that the EU are looking at a lot in their sort of the longer term guidance. It's that kind of, in a way, helping employers to help themselves is the way I would describe it. Because as we touched on earlier, the average kind of busy executive, A, they don't have the time, and B, they really don't know where to start. But if you make it a bit easier for them to do that interrogation better, then that helps everyone.
What a great way to end it. I especially liked hope is a terrible legal strategy. And I'm sure every lawyer in the room and every lawyer out there agrees with you, John.
But it's trademarked now,
I know.
so
I need to get that on coffee mugs quickly.
Yes. And send us one. And then instead of using his instead of using his college recruiter mug or I using my AIM group mug when I'm at home, we'll use Hope is a Terrible Legal Strategy mugs. And thank you, gentlemen, all three of you, for joining us today. It's been a lot of fun. We're going to turn this into an article for the AIM group, and we'll send it to you when it comes out. And yeah, it's been a lot of fun, but it's also been some very serious and meaningful stuff. And I hope all of our clients and friends who listen in take it to heart. Thank you.
Thanks,
Thank you
guys.
so much.
Cheers.